Hello everyone, welcome back to my channel. Don't forget to like, comment, and subscribe. So today I will tell you about Florida offshore injury lawyers. Okay, offshore workers often face workplace dangers. Though these employees play a key role in the US economy, they encounter risky work environment. Offshore workers are 7 times more likely to be killed on the job than employees in the other industries. When a worker is injured or killed on the job, the employee and their family may struggle. On top of medical bills, the worker has likely lost the ability to earn necessary income. All the while, oil industry employers try to blame the workers for the accident and avoid paying compensation. If this sounds like an overwhelming situation, it is. However, you don't have to handle an offshore injury accident alone. If you were injured or you lost your loved one in an offshore accident, you need a knowledgeable maritime accident attorney on your side. Our Florida offshore accident lawyers are committed to protecting your rights. You don't want to fight the powerful oil industry on your own. An offshore injury attorney can help you understand your right and fight for the compensation you deserve. It's important to hire a maritime injury attorney who understands the detailed differences between maritime law and land-based employment law. When an accident occurs at sea, international, federal, and local laws may all apply to your case. So, you need a team of attorneys experienced in personal injury litigation fighting for you. Maritime law is a system all its own, and you should trust your claim only to someone with plenty of experience in this field. At Grossman Attorneys at Law, we have been helping employees who experience catastrophic accident for decades. Here we all will share an overview of offshore workplace injuries as well as the legal remedies available to offshore workers. If you have been injured in an offshore accident, our experienced maritime lawyer are ready to help you get the compensation you deserve. Contact us today to get started. And then what causes offshore injuries? A dangerous maritime environment combined with heavy equipment and explosive chemical treaties creates the possibility of workplace accident from transportation to the workplace to dangerous conditions on site. Offshore workplace are riddled with potential hazard. Here are some of the cases of offshore injuries. The first, explosions. When chemical build up in enclosed spaces or combined with other substances. And then fires when combustible materials ignite. And then number 3, slip and falls on wet surfaces or unstable platforms. And then number 4, machinery malfunctions from manufacturing defect or worker error. And number 5, exposure to toxic chemicals involved in oil extraction. And the last is enclosed spaces that increase the risk of injury in an accident. While not all offshore injuries are preventable, workers often suffer the consequences of employer negligence. The employer has the duty to provide a safe work environment, and when you face unsafe conditions, your employer could be liable for the harm you suffer. What injuries do offshore workers sustain? Dangerous offshore work environment can lead to life-altering injuries, including this: burns, several limbs, and then traumatic brain injuries, and then broken bones, and then tissue damage, internal organ damage, neck injuries, spinal cord injuries, and respiratory problems. Unfortunately, not all maritime workers survive an offshore accident that result in injuries. The severe nature of many offshore accidents means that maritime workers are killed each year. What legal options are available to offshore injury victims in Florida? An injured offshore worker has several legal options. Depending on the specific of the accident, maritime injuries are governed by different laws that land past injuries. So, a traditional workers' compensation attorney might not know how to help. However, at Grossman Attorneys at Law, we know maritime law and use our insight to fight for your maximum compensation. Maritime law, also referred to as an admiralty law, governs activities on navigable waters. Navigable waters include any body of water capable of being used for interstate or foreign commerce. For example, a river running across state lines is a navigable water governed by maritime law, but a lake solely within a single state is not. Maritime law encompasses international, federal, and local laws. When you are injured while working at sea, our maritime injury lawyers will evaluate two primary methods of compensation. And then maritime common law. Under maritime common law, a worker injured at sea is entitled to maintenance and care. You may compare this payment to what a land-based worker receives from workers' compensation. Maintenance is your daily living expenses such as room, board, food, and transportation. Care is any necessary medical expenses associated with your injury, such as hospital and doctor bills, surgery expenses, prescriptions, medical equipment, and testing costs. Maintenance and care won't provide significant compensation, but it can help. One advantage of maintenance and care is that it is a no-fault system of compensation. It allows for payment for injuries and even diseases or conditions that arise while in service of the vessel. This means that even if you were responsible for your accident, you can still claim compensation. And then the next Jones Act lawsuit. The Jones Act is a federal law that gives maritime workers the right to sue their employers for workplace injuries. To file a lawsuit under the Jones Act, a worker must be classified as a seaman. To be classified as a seaman, a worker must meet this requirement. The first, contribute to the operation of a vessel on navigable waters and spend 30% or more of work time in the service of a vessel. And then employees such as ship crew, fishers, cooks, and vessels, oil rig workers, and others may be considered seamen under the Jones Act. And then Jones Act negligence. A lawsuit under the Jones Act is a fault-based. This means that you must prove that your employer's negligence caused your injury. If you were entirely responsible for your accident, you cannot sue under the Jones Act. But if your employer is even the slightest bit negligent, you may still recover. This means that a maritime lawsuit requires evidence of wrongdoing, which is not necessary to claim maintenance and care. Jones Act damages. However, a Jones Act claim can provide you with substantially more money. Under the Jones Act, you can recover for economic and non-economic damages, including the following. Okay, the following under the Jones Act, I will explain in the next video. So, don't forget to subscribe and turn on the notification of this channel. Thanks for watching. Don't forget to like, comment, and don't forget to like, comment this video. See you in the next video and bye bye.